Gary Slappy, for the record, for the court.
Yes,
Thank
thank
you.
you.
This courtroom session opens with a pace that immediately signals one thing. Decisions here are not slow, and they are not forgiving. Within seconds, attorneys are stepping in, cases are being called, and the judge is already in control of the flow. But what might look like routine procedure on the surface is actually a series of high-stakes moments where every word matters. Behind each short exchange, there's a deeper reality. People's lives are being shaped in real time. Bond decisions, plea discussions, adjournments. These aren't just legal formalities. They determine who walks free, who stays behind bars, and who faces long-term consequences. And here's what you need to understand from the start. This courtroom isn't just reacting to what's happening today. It's constantly weighing the past against the present. Every defendant carries a history into this room, and the judge has to decide, does that history define the risk moving forward? Pay attention to how quickly tone shifts when key details emerge. One moment it's procedural, the next it becomes intense and deeply consequential. Now think about this as you watch everything unfold. Should the system focus on giving people second chances, or should it prioritize preventing potential harm at all costs? Because in this courtroom, those two ideas are constantly colliding, and the decisions that come out of it are immediate and final.
Your Honor, I was recently appointed. I did meet with Mr. Slappy, but there is additional discovery that I need to review.
Okay, so you're looking, all right.
Yes,
So
please.
let's go. Probable cause conference, August 24th, 2023, 9 a.m. Bond will continue.
Actually, I forgot, Your Honor, Mr. Slappy did want me to address the bond.
Okay, go for it.
Okay, his bond, I believe, is currently set at $100,000. Mr. Slappy does live in the area and help to take care of his mother. He is requesting a lower bond and or a PR with the tether.
Respond.
Your Honor, the people are opposed to the request. The defendant, to give the court a little bit of the background here, the defendant was actively assaulting a woman when two honorable observers saw this and attempted to intervene to protect the woman that the defendant was assaulting. He then turned on them with a knife, stabbing one of the gentlemen 2 times, resulting in that man's hospitalization. In addition to that, the defendant he was previously charged and prosecuted for homicide, which resulted in a 2008 manslaughter conviction of the defendant. These 2 things combined make his guidelines substantial. If I was not as harsh on him in the guidelines, they're as low as 29 months to 57 months. The defendant certainly poses a risk of danger to the community, and he is looking at a pretty substantial prison sentence here.
Anything additional, Ms. White?
No, Your Honor, I was not aware of some of these things. No, Your Honor.
I didn't think so. Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case. Court does call the case of the People versus Benjamin Bridges.
Notice the shift here. New case, new defendant, but the same relentless pace. There's no pause, no emotional reset. The system just keeps moving. This is where a lot of viewers underestimate what's happening. It might seem like minor scheduling, adjournments, contact issues, but this stage is actually critical. When a defendant hasn't communicated with their attorney, it immediately raises concerns about preparedness and cooperation. And look at how the judge handles it. Direct, clear, and firm. Instructions are given, expectations are set, and there's no room for confusion. Call the number, provide contact details, do it immediately. These aren't suggestions, they're requirements. And failure to follow through can create problems later, especially when the court starts evaluating credibility and compliance. Saki, here's the bigger picture. Cases aren't just decided by evidence, they're influenced by behavior. Showing responsibility, staying in contact, following instructions, these things matter more than people think. So ask yourself this, if a defendant can't even maintain basic communication with their own lawyer, how does that impact the court's confidence in them overall? Because in a system built on structure and accountability, even small missteps can carry serious weight.
Alex Chabalowski on behalf of the people.
Ready, Judge. Torshel Feaster, Assistant Public Defender on behalf of Mr. Benjamin Bridges. Mr. Bridges, please state your name for the record.
Benjamin Bridges.
All right, what are we doing?
Not much today, Judge. I have had no contact yet with Mr. Bridges. Mr. Bridges, I've put my phone number in the chat. If the judge would kindly give us an adjournment, if you would call us so we can try to move this forward.
All right. Probable cause conference, August 31st, 2023,
All right.
9 a.m. And Mr. Bridges,
Yes.
you can look at the phone number that he's putting in the chat, but also I'm going to give you a phone number I need you to call.
Okay.
And that's area code 734-222-6970. That's the Washtenaw County Public Defender's Office. You need to
Okay.
call there. Give them a valid phone number for yourself as well as an email. You should do that immediately upon signing off from this hearing. You
All right.
understand
Sounds
that?
good. Thank you.
Bond continued. Thank you. Court does call the case. People versus Scott Fenner.
Jessica Lynch on behalf of people.
Ron Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Fenner. Mr. Fenner, please state your name for the record.
Scott Fenner.
Your Honor, today is the date and time set for probable cause conference. We will be doing plenty, but also not today. Because there is further investigation that's going on in this case, and there also may be issues of competency, what we're first going to do is ask for an adjournment to allow the prosecution to perhaps finish their investigation and see if there are going to be other charges. After that, then we'll look at what we'll do concerning the competency.
Okay, so how much time are you guys gonna need to do all that?
I'm going to rely on sister counsel to give us a good idea.
Judge, I would say 3 to 4 weeks, to be honest. And my medical examiner, even on this case, isn't available till September 12th.
Now, this is where the legal process slows down, but not because the case is simple. It slows down because it's complicated. The prosecution is asking for time, and not just casually. They're pointing to ongoing investigation and unavailable key personnel like the medical examiner. That's a major factor. Without complete evidence, pushing forward too quickly could weaken the entire case. And then there's the mention of competency issues. That changes everything. Because once competency is in question, the court has to step back and ask, is this person even fit to stand trial right now? This isn't just about facts anymore. It's about mental state, legal capacity, and fairness. The judge's role here becomes balancing two competing pressures: moving the case forward efficiently and ensuring that the process remains just and valid. But here's the tension. Delays can feel frustrating, especially when serious allegations are involved. So consider this. Is it better to delay justice to ensure accuracy, or move quickly and risk getting it wrong? Because in situations like this, every extra week isn't just time. It's a strategic decision.
So I would say 3 or 4 weeks.
Got it. Well, why don't we do this? I'm going to set it for September 14th without objection. 2023, 9 a.m. Bond continued.
Thank you.
As denied.
Thank you.
All right. Thank you. Court calls the case, People versus Anthony Randolph.
Maria Ursinski on behalf of the people.
Ready, Judge. Torshel Feaster, Assistant Public Defender on behalf of Mr. Anthony Randolph. Mr. Randolph, please state your name for the record.
Anthony Randolph.
Thank you, Judge. I've spoken to Ms. Kirby on this matter and to Mr. Randolph every day this week except for yesterday. My understanding is that he is prepared to enter a plea in this matter, Judge, to counts 2 and 3. Count 1 would be dismissed. Ms. Kirby has no objection to his release after the PSI is completed.
A correct statement.
Yes, Your Honor.
So he's pleading guilty to counts 2 and 3,
Yes, Judge.
dismissing count 1.
Yes, Judge.
All right, Mr. Randolph, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name for the record.
Anthony Randolph.
Sir, it is this court's understanding you're going to plead guilty to 2 misdemeanor charges. Is that your understanding?
That is.
The first is the stated count 2 of domestic violence second offense. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
I do.
The other charge is the stated count 3 of malicious destruction of personal property less than $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would be the maximum fine. You understand that?
Yes.
You also understand, sir, that I would not be your sentencing judge in this case, and you would be sentenced before Judge Freshour in the 14A4 District Court.
I do.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of domestic violence second offense, how do you plead?
Guilty.
To the charge of malicious destruction of personal property, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
This is one of the most critical moments in any courtroom, the plea acknowledgement, and the judge is being extremely thorough here for a reason. Every right being listed, the right to trial, the right to question witnesses, the right to remain silent. These are foundational protections in the legal system. And by pleading guilty, the defendant is giving all of them up. That's not a small decision. That's permanent. And notice how the judge keeps confirming understanding. This isn't just formality, it's protection. The court needs to ensure that this plea cannot be challenged later on the basis of confusion or coercion. But here's what makes this moment deeper than it looks. Pleas aren't always about guilt alone. Sometimes they're about avoiding risk. Trials are unpredictable. Sentences can be harsher. So the defendant has to make a calculation, accept a known outcome, or gamble on an uncertain one. Now think about this carefully. If you were facing serious charges, would you fight for a chance at full freedom or take a deal that guarantees a lesser consequence? Because that decision, right here, defines everything that follows.
Yes.
You understand you're giving up your right to appeal of right?
I do.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
I am.
Of your own free will?
Yes.
And because you believe that you're guilty of these offenses?
Yes, Your Honor.
On June 14, 2023, at the location of County State of Michigan, tell this court what you did on that date involving an Angelica Gonzalez that makes you think that you're guilty.
Her and I engaged in a physical altercation that resulted in us wrestling, Your Honor.
If I could help,
All
Judge.
right. You please.
Thank you. Mr. Randolph, on the day and time in question, you were intoxicated, is that correct?
That's correct.
At one point, you took a piece of meat out of the deep freezer and you threw that at the victim in this case. Is that correct?
I do not remember doing that.
Do you recall having a physical altercation with her when you came home drunk that night?
I do.
Do you recall her asking you to leave?
I do.
Do you recall when she tried to get you to leave that you put your hands on her so that you pushing her, not leaving the address on that day and time?
I do recall that.
And you and the victim in this case have a domestic relationship.
That's correct.
Also, while you were at the property, you picked up other items in the home and threw them during this altercation.
Yes, in particular, I remember the pond on the deck.
Okay, and that caused damage to the structure.
I believe so.
Okay. Your Honor, are we close?
This is where the case becomes personal and real. The abstract legal language fades and actual events come into focus. The defendant is now describing actions tied to the charges: physical altercation, property damage, intoxication. And what stands out is the partial memory. I don't remember doing that. That's not uncommon, especially when alcohol is involved. But legally, lack of memory doesn't erase responsibility. The court is focused on what happened, not whether the defendant recalls every detail. And the prosecutor is methodically building that narrative, step by step, confirming each element needed to support the charges. Relationship, established; altercation, confirmed; damage, acknowledged. This is precision. Every answer locks another piece into place. But here's the deeper issue. Intoxication often plays a role in cases like this, and it raises a difficult question. Should being under the influence reduce accountability, or does it actually make the situation more serious? Because from the court's perspective, actions still carry consequences, regardless of what state someone was in when they made them.
Well, I just want to make sure there was personal property of Ms. Gonzalez that by your actions was destroyed that night or damaged?
Yes, I believe it was the pond that was on the deck.
Okay. And had you previously been convicted of domestic violence on or about January 28, 2021?
I was, Your Honor.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
I'm satisfied, Judge.
Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4. Sentencing in this matter will be
August 17th at 9 a.m. with Judge Freshour.
August 17, 2023, 9 a.m. before Judge Freshour. I realize that there is the notion that the defendant could be released after PSI. I will indicate, and I don't know if that's part of his conditions. I have familiarity with this defendant.
Oh,
And I do see it. So I will indicate that defendant may be released into an agreement on PR after the PSI and after scram tether is placed.
Now, this is a nuanced decision, and it shows how the court balances control with conditional freedom. The judge is allowing for release, but not without strict conditions. This isn't full trust, it's monitored trust. The PSI, or pre-sentence investigation, will give the court a deeper look into the defendant's background before final sentencing. And then there's the tether. That's surveillance. That's accountability in real time. So what the judge is essentially saying is, you can have limited freedom, but only under supervision. This is a middle ground. It acknowledges cooperation and progress, but it doesn't ignore risk. And notice the defendant already has a tether on. That detail reinforces the court's caution. Removal isn't automatic. Conditions must be maintained. Here's the real takeaway. Freedom in this context isn't absolute. It's conditional, controlled, and constantly evaluated. So ask yourself, is this a fair balance between giving someone a chance and protecting the public? Or does it still lean too heavily in one direction? Because in cases like this, that balance is everything.
Your
So
Honor,
he
I
has,
have a
the
scram
scram tether has, I'm sorry?
I currently still have a scram tether on my leg, Your Honor.
Okay, but if they try to take it off, you have to have that scram before you leave. That's my condition. Bond will continue with that caveat. Thank you.
thank you, Judge.
Thank you, Your Honor.
Court does call the case, People versus Shannon and Galvin.
We're ready in that matter, Your Honor.
Ms. Kirby?
I handle both sides if you like. Senator Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Galvin. Mr. Galvin, could you state your name for the record?
And Dalton Galvin.
Thank you.
Your Honor, today is a date. I'm sorry.
No, go ahead, sir.
Today is the date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination at the first available date.
Preliminary examination will be set August 22nd, 2023, 9 a.m. in person. That is before Judge Washington.
Thank you, Your Honor.
And Your Honor, this
Yes.
was also set for a bond violation hearing by Ms. Gaines and myself the same day as the previous. The defendant's phone privileges were revoked as he was calling the victim numerous times. I did send over those calls to Mr. Brown.
This is where things take a sharp turn, and it's not about the original charges anymore. It's about violating the court's trust. The prosecution is laying out something serious here: repeated contact with the victim despite restrictions. And not just once, multiple attempts using different inmates' accounts to bypass the system. That's not accidental. That's deliberate behavior. In the eyes of the court, this signals one thing: non-compliance. And that's dangerous for any defendant, because when someone ignores direct or implied boundaries like this, it raises a much bigger concern. Will they follow any court order at all? Notice how the prosecutor emphasizes the pattern: different PINs, repeated calls, intentional workarounds. This isn't being framed as a mistake. It's being framed as calculated. And here's the impact. This kind of behavior can destroy credibility instantly. Even if the original case had room for negotiation, actions like this tighten everything. So consider this carefully. If someone continues contacting a victim after being restricted, should the court respond with stricter control or give them another chance? Because in this moment, the defendant isn't just being judged for the past. They're being judged for what they're doing right now.
We last had a hearing on the 27th of July, and on July 30th, the defendant began calling from other inmates' PINs, saying, "I'm using someone else's tablet and someone else's PINs." There's 3 people's PINs that he is currently using. So I would ask for the court to block the victim's number from the jail.
And we have no response to that. Ms. Kirby did send the calls to our office. And I have spoken with my client about this. We leave it to the court's discretion.
The defendant's bond will continue. His phone privileges will remain revoked, and the victim's number that the prosecutor will provide to the Washington County Jail is to be blocked from any outgoing calls.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Alexis Jenkins.
Maria
2
Simpson
cases.
on behalf of the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Alexis Jenkins. Alexis, could you please state your name for the court?
Yes, Alexis Brown Jenkins.
Your Honor, it is our intention to waive the preliminary examinations and agree to be bound over to circuit court.
This is a strategic legal decision, and it might not be obvious at first glance. Waiving a preliminary examination means the defense is choosing not to challenge probable cause at this stage. Instead, they're allowing the case to move directly to a higher court. Why would they do that? Because sometimes the evidence is already strong enough that fighting it early doesn't provide any advantage. Instead, the focus shifts to long-term strategy, negotiations, plea options, or trial preparation at the circuit level. The judge carefully explains the rights being waived, ensuring the defendant understands that this is not a minor step. Once waived, that opportunity is gone. This is where legal planning becomes critical. Every move is calculated, not emotional. And here's the bigger picture. This decision can save time. When it reduce legal exposure in early hearings and shift the battle to a stage where more options might exist. So ask yourself this: is it smarter to fight every step of a case or choose your battles where they matter most? Because in legal strategy, timing is everything.
Mr. Jenkins, is that correct?
Yes, Your Honor.
You understand the preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes. I understand.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
I understand, Your Honor. Thank you.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant in both cases is bound over on count one. In the case ending 1-2-2-3, counts 2 and 3 will follow in that case.
Your Honor, we waive any further reading of the information, acknowledge receipt, ask the court to continue not guilty pleas, and ask for a circuit court pretrial date.
Defendant having waived formal reading, pleading not guilty, court will enter not guilty pleas on all of these cases, on all counts, I should say. Pretrial in these matters will be set for
August 23rd at 1:30 p.m. with Judge Conlon.
August 23rd, 2023, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you.
Thank you. Bond will continue. Court calls the case of the people versus Mikkel Hasley.
Nicole Hughes on behalf of the people.
Sam Bernstein with and on behalf of Mr. Housey. Mr. Housey, could you please state your name for the court?
Okay, what are we doing?
Your Honor, Mr. Housey wishes to continue to preliminary examination. I am hoping that this doesn't get scheduled on the 22nd. Please, I have a firm conflict.
People wouldn't be ready on the 15th.
Need to make sure. I don't know. We could try, but I don't know.
Everybody to be ready, so preliminary examination will be set August 29th, 2023, 9 a.m. before Judge Freshour. It's defense that's asking not to set it for the 22nd, so I'm going to set it for the 29th. Bond in this matter will continue.
Here again, you see a pattern. Cases moving forward, schedules being set, and bond decisions remaining unchanged. But don't mistake repetition for simplicity. Every time bond is continued, the court is reaffirming its stance. Nothing has changed enough to justify release or modification, and that's key. Bond isn't static. It can be revisited. But for it to change, there needs to be new information, new arguments, or new circumstances. Without that, the court defaults to maintaining the current conditions. In this case, the focus is clearly on preparing for the next major step, the preliminary examination. That's where evidence will start being tested more directly. Until then, the court is essentially holding the line. Now consider this. Should courts be more flexible with bond decisions as cases progress? Or is consistency more important than adjustment? Because every continued bond reflects a choice to prioritize stability over reconsideration.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the people versus Mann Davis.
Caitlin Kirby on behalf of the people.
Sandra White on behalf of Mann Davis.
Mr. Davis, state your name. They'll need to unmute you.
Say it one more time. Mann Davis.
Thank you, sir. All right. What are we doing?
Your Honor, in this matter, we'd like to set it for a preliminary exam, and I would like to address bond.
Preliminary examination in this matter will be in person, August 22nd, 2023, 9 a.m. And that is before Judge Barr. As to bond.
Your Honor, Mr. Davis has lived in the area his entire life. He does have a job, and he is willing to do an alcohol tether.
Response.
Your Honor, Mr. Davis has a very long criminal history. He has multiple violent offenses in the past. And earlier this year, he also had a domestic violence third that was dismissed. I would ask, since the preliminary examination is 12 days away, that the bond remain the same and it can be re-reviewed after exam.
Defendant's motion for bond reduction, given the circumstances of this case, is denied. Bond will continue Certainly it can be re-examined after the exam day. Thank you.
Thank you. Thank you.
This is another moment where history becomes the deciding factor. The defense presents stability, lives in the area, has a job, willing to comply with monitoring. But the prosecution counters with something far heavier, a long record of violent behavior. And just like earlier, that shifts the entire perspective. Because the court isn't just evaluating who the defendant claims to be today, it's evaluating patterns, repetition, risk. And notice how quickly the judge responds. Bond reduction denied. Again, no hesitation. That tells you one thing. The weight of past offenses outweighed any argument for leniency. This is a recurring theme throughout this session. When violence is part of the history, the court becomes significantly more cautious. So here's the question. At what point does someone's past become too heavy to overcome in the eyes of the court? Because in cases like this, redemption isn't just about change. It's about convincing the system that the change is real.
Court calls the case, People versus Norman Johnson.
Caitlin Kirby on behalf of the people.
Sam Bernstein for Mr. Johnson. Mr. Johnson, could you please state your name for the court?
Norman Johnson.
Thank you. All right, what are we doing?
Mr. Johnson wishes to set this for a preliminary examination, Your Honor. I, again, am hoping for a date other than the 22nd.
Preliminary examination, August 29th, 2023, 9 a.m. That will be before, gotta balance it. Is it us or? Okay. Before me.
Thank you, Your Honor.
Bond will, that's in person. Bond will continue. Thank you. Court does call the case, People versus Cameron Bright.
Image Ganatra for the people.
And Assistant Public Defender Emily New on behalf of Cameron Bright.
Mr. Bright, please state your name.
Cameron Bright.
Okay, what are we doing?
Your Honor, we have not been able to get in touch with Mr. Bright, so we are going to ask for an adjournment and that Mr. Bright call our office and leave a phone number, or Mr. Bright, I sent you an email. If you could, you can also just email me back with a phone number if you got that email.
Mr. Bright,
Yes,
I'm going to
sir.
adjourn the probable cause conference to August 31st, 2023,
Yes, sir.
9 a.m. Mr. Bright, I'm going to give you a phone number you need to call. You ready?
Yes, sir.
Area code 734-222-6970. Immediately up, after disconnecting from this Zoom hearing, you are to call that number. That's the Washington County Public Defender's Office. You're to leave a phone number and a valid email address. Understood?
Absolutely. Yes, sir.
Thank you. Bond in this matter will continue.
Thank you.
This might seem routine, but it reflects something deeper about courtroom control and expectations. The judge is not just managing cases, he's managing behavior. Clear instructions, immediate compliance, no excuses. That's the standard being set. And when defendants fail to maintain communication, it creates delays, confusion, and potential legal setbacks. That's why the judge repeats the instruction. Call immediately. Provide valid information. This is about accountability. What's interesting is how consistent this pattern is across multiple cases. Different defendants, different situations, but the same requirement. Engage with the process properly. Because without that, the entire system breaks down. Now think about this. Do you believe most defendants fully understand how important these small instructions are, or do they underestimate their impact? Because in reality, these small details often shape how the court views someone moving forward.
Court calls the case, People versus Candace Butler.
Alexander on behalf of the people.
Ready again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Candace Butler. Please unmute and state your name for the record.
Candace Butler.
Thank you, Judge. This is another case that I don't think we're able to get much done on today, as I have not spoken with Miss Butler. I did put my phone number in the chat, Miss Butler. I'm asking the judge for a brief adjournment so we can talk and try to get this matter resolved.
All right, would we be able to do that today? Or
Yes, the number's in the chat. You can call this afternoon. Sorry, Judge.
No, it's
Okay,
okay.
I'm sorry about that.
Probable cause conference, August 31st, 2023, 9 a.m. Bond continued. Ms. Butler, other than, you can call Mr. Feaster, but I also need you to call the Washtenaw County Public Defender's Office.
Okay.
You got that number?
I do not.
All right. You got something to write with?
I can grab something if that's okay.
Go
or
for it. Go ahead and grab it, because I'm going to tell you, I'm going to give you a number to call.
Okay, yes, sir.
You ready?
Yes.
Okay. Area code 734 222 6970.
Oh man.
You got it?
I do, yes, sir.
All right. After you hang up, you need to call there, give them a valid phone number as well as a valid email address.
Okay, yes, sir.
All right. Bond in
All
this matter will continue. Thank you.
All right, thank you.
Judge.
I have an interpreter.
You have an interpreter ready? All right.
Good morning, Mr. Interpreter. You're in front of the Honorable Jake Cedric Simpson out of the 14A1 District Court, Washtenaw County, State of Michigan. Our number is 1423.
Thank you very much. Good morning. I'm Maggie, Spanish interpreter, ID number 218146. Good morning, Your Honor.
Good morning, Madam Interpreter. Court does call the case, People State of Michigan versus Edwin Miranda Cardoza.
Llamamos el caso de el estado de Michigan contra Edwin Miranda Cardoza.
Marie Rosinski on behalf of the people.
Hold on before you go on. Miss Weidling, you were a little bit slow on the draw. Can I have the interpreter sworn, please? I know it's your.
Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in a manner not before the court, so help you God?
I do.
Thank you.
All right. You can go ahead with your appearance, counsel.
Puede proseguir con las comparecencias, abogada.
Marie Rosinski on behalf of the people.
Marie Rosinski, en nombre del pueblo.
Alex Warren Green on behalf of Mr. Miranda Cardoza.
Alex Warren Green, a nombre del señor Miranda Cardoza.
Okay, what are we doing on this case today?
Muy bien, ¿qué vamos a hacer en este caso el día de hoy?
Your Honor, I'm requesting an adjournment in this matter.
Su señoría, estoy solicitando un aplazamiento en este caso.
With respect to our duties under Padilla v. Kentucky, we've referred Mr. Miranda Cardoza to Immigration Counsel.
This is a critical legal reference, and it introduces consequences far beyond this courtroom. The mention of Padilla versus Kentucky changes the entire context of this case. What this means is simple but powerful. Defense attorneys are required to inform non-citizen defendants about the immigration consequences of a conviction. That includes deportation risks, visa issues, and long-term residency impact. So now this case isn't just about criminal charges, it's about potential removal from the country. And look at the complication. The defendant may need to be out of custody to properly consult immigration counsel. That creates tension. The defense is essentially arguing for bond reduction to allow that consultation. But the judge is skeptical. The court hasn't heard of such limitations before, and without strong justification, that argument loses weight. This is where legal systems overlap. Criminal law meets immigration law, and when they collide, the consequences can multiply quickly. Now ask yourself, should someone's immigration status influence how a criminal case is handled, or should those systems remain completely separate? Because in reality, they are deeply connected, and decisions here can echo far beyond the courtroom.
También con respecto a el tema de el estado de Kentucky, que usted había referido al señor Miranda Cardoza a Consejería de Migración.
If I may briefly address bond as well, when the court's prepared for that, Your Honor.
Si brevemente pudiera referirme a la fianza, su señoría, o cuando el tribunal esté preparado para eso.
Would he be able to have the consultation with the attorney within 2 weeks? or did he need 3?
Él podría hacer esa consulta con el abogado en un lapso de 2 semanas o necesitaría 3 semanas.
Your Honor, when we spoke to the Michigan Immigrant Rights Center, they informed us they would not be able to do a consultation while Mr. Miranda Cardoza is in custody.
Su señoría, cuando hicimos la consulta con el Centro de Derechos de Inmigrantes de Michigan, ellos nos indicaron que no podrían hacer la consulta mientras el señor Miranda Cardoza esté bajo custodia.
This place says that because I've never heard that before.
Bueno, ¿cómo es que este lugar dijo eso? Porque nunca había escuchado eso antes.
And Your Honor, my basis for making a bond argument would have been that he would need to be out of custody to speak with the Immigrant Rights Center. If the court's not inclined to modify bond or release Mr. Miranda Cardoza on his own personal recognizance, then we would need to look into other counsel that he can work with. I'd request a 3-week adjournment.
Su señoría, con mi base para solicitar la fianza consistiría en que el señor Miranda Cardoza pudiera ser liberado bajo fianza para que él pudiera hacer la consulta con el Centro de Derechos de Michigan. Pero si el tribunal no está inclinado a liberarlo bajo fianza, entonces tendríamos que hacer otros arreglos para que él pueda consultar a algún abogado y sí estoy pidiendo 3 semanas de aplazamiento.
If that is the basis for the motion for bond reduction, that motion is denied.
Si esa es la base para la reducción de la fianza, esa moción es rechazada.
This case will be adjourned to August 31st, 2023, 9 a.m. Bond will continue.
Este caso se aplaza para el 31 de agosto del 2023 a las 9 de la mañana. La fianza continúa.
Thank you.
Gracias.
Maggie, thank you very much. Always a pleasure.
Same here, Your Honor. Always a pleasure. Thank you for using our services. Good day. Bye-bye.
Bye-bye. Court does call the case. People versus Jonathan Ward Callahan.
Good morning, Your Honor. Grace Broughton appearing on behalf of the people and standing in for the attorney of record, Amy Ryder.
Good morning, Your Honor. Assistant Public Defender Davi Lebo on behalf of Mr. Ward Callahan. Please state your name, sir.
I'm John Callahan.
What are we doing?
Your Honor, in this matter, we'll be seeking a competency evaluation.
Do you have the paperwork come over? No, of course not. So what I would do,
I have it filled out.
I'll order a forensic. We'll set a competency hearing. You need to get the orders over to me today.
This is another major shift, and it brings the focus back to mental capacity. The defense is requesting a competency evaluation, which means they're questioning whether the defendant can fully understand the legal process or assist in their own defense. The judge responds immediately, ordering a forensic evaluation and setting a competency hearing. That's a structured, formal process. This isn't optional. Once competency is in question, the court is obligated to address it before proceeding further, because trying someone who isn't mentally fit would undermine the entire legal system. What stands out here is the judge's expectation. Paperwork needs to be submitted quickly, orders need to be signed, and the process must move forward without delay. This is efficiency within complexity. Even when dealing with mental health issues, the system maintains structure and deadlines. Now consider this carefully. Should mental health concerns slow the legal process significantly, or should the system push forward while evaluating them in parallel? Because cases like this sit at the intersection of justice, psychology, and responsibility, and there's no simple answer.
For my signature, I'll set that competency hearing for October 5th, 2023, 9 a.m. Defendant's bond at this time will continue. Thank you.
Thank you, Judge.
Court calls the case, People versus Michael Calvo.
Alec Chabalowski for the people, Your Honor.
Ron Brown appearing on behalf of Mr. Calvo. Your Honor, can I have the case number? Because there's two Calvos on the docket.
Okay, this case number is 23 FB 1058.
Thank you. Thank you, Your Honor. Ron Brown appearing on behalf of Michael Calvo.
I have two files. There's
What, their father's son, they got different birthdays. Or
Oh.
they got the same name. with
so this one is Calvo, not the second. So
them. It's the first then, the older one.
The father.
okay. All right.
And Michael Calvo signed in, but I don't know who he is.
Okay, I have Michael Calvo, and this case, the date of birth on this case is
470.
Why are you interrupting? Why is he interrupting? I don't have a date of birth on that information. Let me just double check it.
All right, you're on 1058, right?
I'm on 1058.
8/4 of 70.
8/4 of 70 is the date of birth on this one, on 1080, on 1058.
That's me, Your Honor.
All right.
Can you hear me?
Yeah, I can hear you. Okay, what are we, this case?
Your Honor, I'm requesting an adjournment. We're still trying to work through the restitution.
Probable cause conference, August 31st, 2023, 9 a.m. Bond continued.
Thank you.
Thank you. Court does call the case of People versus, is it Quing Newton?
It's King. On behalf of the people.
Ready, Judge.
It's King with a Q. All right, I got you. All right.
Torshio Feaster, Assistant Public Defender on behalf of Mr. Newton. Mr. Newton, please state your name for the record.
King Newton.
Thank you, Judge. I've met with Mr. Newton. I spoke to Ms. Hughes on this matter. If we could adjourn this 1 week so I can get the mental health referral into the court. This is our first PCC.
I have it.
Oh, okay. Well, thank you then. If the court would not mind signing that and adjourning this out for 3 or 4 weeks, we're going to have him referred and see if we can get him some help, Judge.
All right. I will adjourn this out then to September 7th, 2023, 9 a.m. I've signed the referral and everything. His bond will continue in this matter.
Thank you, Judge.
What you've just witnessed is a full spectrum of courtroom decision-making compressed into a single session. From bond arguments and plea deals to competency evaluations and procedural rulings, every case carried its own weight. But the underlying themes remained consistent. The court prioritized risk assessment, behavioral patterns, and legal structure above all else. Past offenses repeatedly influenced present decisions. Compliance, or lack of it, directly impacted outcomes. And strategic legal moves like plea agreements or waived hearings shaped how each case progressed. You also saw how the system handles complexity. Mental health concerns triggered formal evaluations. Immigration implications introduced additional legal layers. And even something as simple as communication with an attorney became a critical factor in how defendants were perceived. At its core, this session highlights a fundamental truth. The courtroom is not just about what happened. It's about what might happen next. Every ruling reflects an attempt to balance fairness with public safety. And that balance isn't always clean. It's calculated, sometimes harsh, but always deliberate. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.